case briefs, and so much more. LSData's got what you're looking for.
A 1981 Supreme Court case, Allstate Insurance v. Hague, centered on determining which state's law to apply in a case involving a motorcycle accident in Wisconsin and an insurance policy for the deceased Wisconsin resident. The question was whether Minnesota or Wisconsin law should apply to the policy provision allowing the stacking of insurance policies. The Minnesota Supreme Court used Professor Leflar's method to examine the contacts of the state with the parties, ultimately deciding that Minnesota law was applicable and the insurance coverages could be stacked for total coverage of $45,000. The case was brought to the Supreme Court to determine if the Due Process Clause of the 14th Amendment or the Full Faith and Credit Clause of Art. Section 1 of the United States Constitution barred the choice of Minnesota law. The court decided that Minnesota had sufficient connections to the parties and the litigation, making the choice constitutional. Factors considered included the respondent's Minnesota residency, appointment as a personal representative, and policy reference to Minnesota. With no evidence of forum shopping and Minnesota's interest in ensuring the worker didn't become a public charge, the decision didn't violate the due process or full faith and credit clauses.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.